Sometimes the best thing you could do is shut up. I say this a lot. Ron White, the comedian, got arrested when he was young for being drunk. He said, I had the right to remain silent, but I did not have the ability. The best thing you could have done is just got out of there. And it wasn't your business, and then you just made it harder for the police. They're dealing with two drunk kids and a party, and there you are causing a ruckus. All right, let's talk to Hugo Opreza. This is file 261128FY. Mr. Opreza, you're charged with 2 counts of resisting, obstructing a police officer. Those are felonies. They're punishable by up to 2 years imprisonment. It alleged that on or about June 6th in the city of Sturgis, that you did resist or obstruct Dylan Ware and Jason Van Dyken of the Sheriff's Department. Dylan Ware, Sturgis. Jason Van Dyken seems to be in everything. Those cases will be dismissed if you enter a plea to count 3, being a disorderly person by being intoxicated. That's a misdemeanor punishable by up to 90 days in jail and a fine of up to $500. Mr. Gabriel, you confirm the plea offer?
I do, Your Honor.
Mr. Bush, you confirm as well?
Yes, Your Honor.
Mr. Opreza, are you going to plead to being a drunk and disorderly on June 6th in the city of Sturgis? Yes?
Yeah.
Yes.
Anyone threaten you to get you to do that? Anybody threaten you to get you to try to plead to that charge?
No.
Or promise you anything?
No.
All right, this applies to you and everybody else here. Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that?
Yes.
If it was a trial, you'd have the right to be represented by an attorney. Mr. Bush is here on your behalf. You would also could hire an attorney of your own choosing if you wish. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand on your own behalf and testify. But you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes.
All right, well, let's talk about this. This was just before midnight on June 8th. And they got sent to an address, and there was a 17-year-old unconscious in the parking lot. And then they were currently handling the arrest of a highly intoxicated 20-year-old. There was a party. Then Hugo Opreza tried aggressively pushing past his wife at me when I told him to go sit in his truck. Due to his level of intoxication, he kept aggressively approaching me. Your blood alcohol is a 0.142. Was this party at your house?
No, it was a place.
It was a banquet hall north of Sturgis,
All
Sherman.
right. How did you happen to be there?
I know that people that was having a party, so me and my girlfriend, we went with my
Well,
kids.
apparently there were some drunk underage people there and then you didn't help things. What were you trying to do? See what was going on?
Yeah, so I have kids and I didn't know, I just wanted to make sure my kids were okay. So I stepped outside, but
Well, that ain't the way to do it. Had to pepper spray you. And they gotta put you in the car and that corrupts the inside of the car. All right, what were you drinking?
I had some beer and then they gave me tequila. They gave me some shots of tequila.
That'll do it. Sometimes the best thing you could do is shut up. I say this a lot. Ron White, the comedian, got arrested when he was young for being drunk. He said, I had the right to remain silent, but I did not have the ability. Best thing you could have done is just got out of there. It wasn't your business, and then you just made it harder for the police. They're dealing with two drunk kids and a party, and there you are causing a ruckus. All right, you got
Your Honor.
arrested on the 7th,
Your Honor,
yes?
before the court accepts the plea, we need to put on the record that Mr. Apreza is aware that there may be immigration impact on this and that he understands that and he's willing to go forward with the plea. Somebody just filed a motion to try to withdraw.
Yes, we
a plea
did,
in
and,
2014, and
well, I believe I advised him of his rights. And I don't know, Mr. Appraiser, whether you've got lawful residency status or not, just because somebody has a Hispanic surname doesn't mean.
Yeah, he's had a green card for over 20 years.
All right, well, so you have lawful residency status, but any misdemeanor could have an impact on your, status. Do you understand? Yes?
Yes.
All right. The
Thank you.
case that Mr. Gabriel's referring to was 12 years ago. He pled to a minor charge. And now the process took so long to go through, they're trying to deport him in part as a result of that conviction that was here in St. Joe County. All right, anyway, did he ever get printed? All right, defendant was printed. Looks like you spent 2 days in jail. You posted a $100 bond. I see your shirt. Do you work at Myers?
Yeah. Yeah, Myers Industry.
Yes.
I've been there for 20 years.
He has support letters from his supervisors there.
I don't doubt it. There is a specific statute for drunken disorderly. We often use disturbing the peace, which is 750-170. Disorderly person comes in a 167, 750-167. Comes in several different varieties, including just plain old drunk and disorderly. That's just exactly what this was. Or 2 days jail, credit 2 days, leaving 0 days to serve. $75 fine, $75 crime victims' rights fee, a $50 state minimum fee, and $150 attorney fee. You post $100, which is a 10% of a bond. That means I have $90 to apply to fines and costs. You owe $260. Can you pay that today or do you need time to pay
Yeah.
it? Very good. Now, it is unlikely that this is going to have any effect on your immigration status. But it points out, even after 20 years, how tenuous the circumstance could be. You've got lawful status, you've worked here for a long time. As you know, we've got lots of people that don't have any status. And every day they're walking on thin ice and they're just not careful.
Get the Michigan driver's license also.
Yeah, he's valid. I don't think this is gonna affect him. But you need to be careful. All right, the court officer will take you out there. Pay the fine. All right, let's try again for Rachel Patain. We called her and she wasn't in the courtroom. That party sounded like a real fun thing for the cops. You got passed out teenagers and loud noise and angry dads who were also drunk. Good morning. Are you Rachel Suzanne Patain?
Hi.
This is file number 261126. You were charged with assault in a domestic relationship with Beverly Fagino, assault by strangulation, count 2, domestic violence. The first count is a felony punishable by up to 10 years imprisonment and a fine of up to $5,000. The second count is a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. That one does allow for a deferral. According to Chief Assistant Prosecutor Mr. Gabry, they're offering to dismiss both of those charges if you plead no contest to assault and battery. Is that your understanding?
Yes, sir.
Mr. Gabry, you confirm that?
I can, Your Honor, and I just indicate for the record that apparently our victim in this matter provided the defendant with a copy of, with her actual victim impact statement in which she wrote a letter. Mr. Bush did get that, provided that to me. In this case, the victim is a defendant in another matter that I'm handling. I read the letter, and in light of statements that she makes about this young lady's physical condition that might have had an impact, I've decided to reduce the charge down as low as I did.
All right. Assault and battery is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It doesn't have a deferral provision like domestic violence does, but it is the same consequence, 90 days and or $500. You spent looks like the 5th.
We were thinking she was in there for 6.
She was in there from the 5th to the 12th, which I think is 7 days. Does that sound right?
I thought, yeah,
All right. Let me ask you this. Did anybody threaten you to get you to plead no contest to this charge
no, sir,
or promise you anything?
no, sir.
Well, you've been waiting, I think you were in the courtroom finally, when I went through the advice of rights. You understand you have those same rights, you're giving those up by entering this plea?
Yes, sir.
All right, by pleading no contest, you don't admit what happened, but you also don't deny what happened. And you would allow or accept that a conviction would enter. Is that what you wish to do?
Yes, sir.
All right, let's see what I got for a factual basis. As Mr. Gabriel indicated, Beverly Fagino was the defendant in another case. And I met with her a week or so ago. I think it was at this same location.
Yes,
She
sir.
was bound over to circuit court, I think. She was charged with a meth charge. I guess that's it. All right, who was Beverly Fagino to you?
A long, a while, a very long time ago, a couple of years ago, I met her after my sister committed suicide, and she didn't have a place to go, and I let her stay in my
So
home
she was a resident of your household, lived in your house?
very long time ago, and at the time, this time, her sisters asked if I could help with an intervention.
All right, well, I can't ask you too much in a no contest case, but let's see what I got here for a factual basis.
But yeah,
There's a booking form.
she isn't anything to me.
According to the booking form prepared by Sergeant Kilborn. Now this is Rachel Jeski's house. He was here earlier this morning. He had a zoning violation. I'm familiar with this house. That's on Walnut Street. I was dispatched to Rachel Jeski's house for a woman who showed up wearing no shirt and was bleeding. She was identified as Beverly Fagino. She said she was assaulted by Rachel Patain at their apartment at 139 Portage Avenue. Said she was choked. Fagino reported she had to grab Patain by her neck to get her to stop. She went to Jeski's house on foot. They've been together for about 3.5 years.
That's not true, Steve.
She had numerous scratches and red marks on her neck, chest, and arms. And they contacted you. You also had bruises and marks.
It's good.
All right, I guess, Mr. Gabriel, are you satisfied with that as a factual basis?
I am, Your Honor.
Mr. Bush?
Yes, sir.
Ms. Patain, what do you do now?
I'm on disability due to seizures,
Yes, and that was mentioned in here, 1124.
as well as severe anxiety disorder.
So do you get disability or anything?
I do get disability,
All right.
very little.
I'm gonna order 7 days jail credit, 7 days.
Thank you.
And the minimum allowable fine of no, take that back. $125 and the attorney fee of $150. You posted a $3,000 10% bond, so I have $270 worth of bond. $145 attorney fee. That adds up to 270. You posted 270 of bond. So he owes, the fine and cost is 0. Let me make sure I've actually got $300 in this file. Yes. All right, I gave you 7 days, credit 7 days on a no contest plea to assault battery. That will show on your criminal record as an A and B. I used your bond, which is $300 on a $3,000 10% bond, which leaves $270 to apply to your fines and costs. I gave you $270 fines and costs, and it evens out with your bond. So your fine is paid, you serve 7 days. I'll leave it at that. Miss Fagino certainly does seem like she's got some struggles as well. There was a no contact provision in here. It's not in effect anymore. So I don't know, where is she staying?
She stays with that Ray guy that you just stated.
Okay, Ray, she stays at Mr. Jeski's house.
I don't know where I know that she stays there. She also stays at some other people's house. She's homeless.
That's what she told me. She doesn't seem like she's doing real well. The
Um,
matter's bound over to circuit court. Maybe it'll go into a treatment program or something. All right, you're good to go.
Does that doesn't matter, you ever get off my record or not? Okay, thank you so much. Thank you, sir.
All right, Mr. Bush, we'll address your cases. Michael Warner's in custody. Is Rachel Patain here?
Yes, she is.
Is she in the room? Rachel Patain? Can you call the hall outside?
She's been here all morning.
All right, David Partial?
He's
Good morning. So you're David Partial?
Yes, sir.
Here with your lawyer, Mr. John Bush. Mr. Partial, you've been charged with some serious offenses as a result of an accident, possession of methamphetamine, and committing an accident with incapacitating injuries. Mr. Bush has been appointed to represent you. I understand you're making efforts to retain counsel in this matter.
Yes, sir.
Mr. Bush, what can you tell us regarding that?
Mr. Partial has shared with me, I won't get into the financial, that he's cashing in, I believe, his 401k this week.
Yes, sir.
And he showed me email retainer documents with the Grable Law Firm out of Lansing. He has been in touch with them. And it's my belief and understanding that you will be retaining them probably on Friday.
Friday, yes, sir.
And they're asking for the court to consider a 2-week adjournment.
Is that correct, Mr. Partial? You intend to retain counsel?
Yes, sir.
Can't find the darn case. There it is. All right, some of this is going to affect Judge Pattison, because I think by the time it gets to prelim, I'll be on some vacation time, but 2 weeks from today, Mr. Gabriel, you have any objection to this?
No, Your Honor, I asked for some verification that this was actually in the process, and Mr. Bush provided that to me. In light of that, I have no problem with the adjournment, with the understanding that Mr. Bush remains on the case until such time as a substitution of counsel is filed.
As expected, yes.
Mr. Partial, you have a right to have this hearing within 12 days of your arraignment. We're already past that. But do you agree to waive the time? You're on bond to allow this matter to be continued to July 7th.
Yes, sir.
All right, it's set for a pre-exam on July 7th at 8:30 and a prelim if needed. Mr. Graybill should file an appearance. We find this often when large firms from out of county file an appearance. They say, oh, we can't come that day. So you should let your lawyer know this is set for a pre-exam conference on July 7th.
I will.
There's a families of the victims involved in this thing. We kept kicking the can down the road. There's other people involved in this. And we often find that we get attorneys from out of county and their calendars don't mesh with ours. And anyway, this is set for that date. In the meantime, Mr. Bush is an attorney until substitution filed. Are you on pretrial services? Are you with community corrections?
Yes, I am.
Yes, I thought so. Continue to apply with all the terms of your bond.
Yes, sir.
You're good to go.
Thank you, sir.
Okay.
Morning, Ms. Davis. All right, let's see, Mr. Chapa. Good morning, sir.
Good morning.
You're Bradshaw Alexander Chapa.
Yes, Your Honor.
You're charged with assault with intent to commit great bodily harm, resisting, obstructing, and assault and battery. Those matters are set for a pre-exam today. You're here with your lawyer, Mr. John Bush. It's alleged that on June 8th, you assaulted Michelle Foster and resisted Adam Balk of the Sheriff's Department as a fourth habitual offender, which theoretically makes this punishable by up to life imprisonment. And Mr. Bush indicates you wish to have a preliminary examination in this matter. Is that correct?
Yes, sir. From my understanding, whatever offer that was, they were giving me, I'm not sure exactly how that worked, what it was, but I don't think I agree with that.
All right, decline the offer.
I would like to, I thought I clearly explained the offer to him. I'm a little concerned that he doesn't
All right, well,
remember.
why don't you go ahead and put the offer on the record?
Your Honor indicated to Mr. Chapa that he could enter a plea of guilty to resisting and obstructing a police officer as a third habitual, which would increase the maximum would go to 4 years, a maximum. And I would also add a count of aggravated assault on Ms. Foster. And then as a result, I would dismiss the 10-year felony assault, great bodily harm, and the remainder of the sub. So knock the supplement down to a third offender.
All right, at this point, the defendant declines that plea offer. We're gonna set this for a preliminary examination for next Tuesday, June 30th.
Is there any way I can get my preliminary,
Say that again?
is there any way, can I like request for my discovery? Or
Yes,
I still don't really, I didn't get a police report or anything. I don't know.
well, your lawyer should have it, so you'll have an
I
opportunity.
haven't
Do
really
you have
received
the
anything.
discovery, Mr. Bush? That's a legitimate concern, Mr. Chapa.
I have it for him. When I first saw him at the jail, it wasn't available, it hadn't come yet, and he had subsequently bonded out when I took it to the jail to give it to him, so.
Oh, why, thank you, sir. I also
it's
believe
been in the file to give.
All right, and you may, what I would suggest is you schedule an appointment with Mr. Bush between now and next Tuesday to sit down in his office with him and go over this. I don't know if there's any video or other evidence. I can tell you that we are going to be very busy next Tuesday afternoon. We've got a number of serious prelims, but we'll do everything we need to do. Now, there's a bond condition that you're not to have any contact with Ms. Foster. You're also plugged into community corrections. And as far as I can tell, you're complying with those conditions. So I want you to continue to do that. So, Mr. Bush, after you review the police report, you can go over it with Mr. Bush. If you want to have your prelim, I'll be here. If you want to decide you wish to take the plea offer or some other plea offer, we can address that as well. But for now, your next court date is next Tuesday, June 30th, in this room at 1 o'clock. No contact with a complaining witness, and stay in contact and comply with the community corrections conditions of your bond.
Yes, sir.
All right, you're good to go.
Thank you.
I don't see that you owe us any money, so that's a plus. Did he get printed?
Yes, sir.
All right, very good.
Thank you.
Okay. Hello, Deputy Feaster.
Hello, Judge Middleton. How are you?
Well, nice to see you. Thank you.
It is good to see you too, sir. He will be here shortly that you need, okay?
All right, thank you.
You are welcome. Normally, the judge doesn't talk to you.
Good morning, Mr. Warner.
Morning.
This is not the Michael Warner that we spoke about. This young man wasn't born until 1992. I think his father is the Michael Warner we spoke about. But anyway, are you Michael Scott Warner?
Yes.
Mr. Warner, I'm here with your lawyer, Mr. John Bush, and also present is Mr. Gary Gabry, the Chief Assistant Prosecuting Attorney. You got arrested on June 9th for resisting obstructing a police officer. That's a felony. It's punishable by up to 2 years in prison and a fine of up to $2,000. Prosecutor Gabry has agreed to reduce that to a misdemeanor charge of attempting to resist or obstruct a police officer. Attempted resisting obstructing is a misdemeanor. It's punishable by a year in jail maximum and a fine of up to $1,000. Is that correct,
Okay.
Mr.?
It is correct, Your Honor.
They're also not objecting to a sentence of time served. By my calculation, you've been in jail for 15 days. Your lawyer, Mr. Bush, is also here. Mr. Bush, you confirm the plea offer?
Yes, that's accurate, Your Honor.
Mr. Warner, are you going to plead guilty to attempting to resist or obstruct a police officer?
Yes.
Anybody threaten you to get you to do that?
No.
Or promise you anything?
No.
Do you understand that by pleading to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that?
Yes.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Bush has been appointed to represent you. You could also hire an attorney of your own choosing if you wish. If you had a trial, you'd have the right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You'd also have a right to witness stand and testify on your own behalf because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, Your Honor.
All right. You got arrested at about 11 o'clock at night on June 9th. Now, you don't know this, but the Three Rivers Police Department has got a focus on people riding bicycles, skateboards, scooters, on Joshua Drive and in the parking lots behind the stores on the north side.
Okay, yeah.
And they're causing the ruckus and they're damaging the pavement. And so you're on your bicycle on June 9th down there at about 11 o'clock at night. Is that correct?
Yeah.
And the cops turned their lights on and siren and you took off on your bike. Is that correct?
Yes.
You wanted to get to your brother's house.
Yeah.
And you took off and you fell off your bike and they had to stun you and just got a lot worse than it originally was for riding your bike.
Yeah.
Why didn't you just hold still when they got there?
I don't know, just scared me that they're stopping me for riding my bike on the sidewalk. It was
Yeah,
new to me.
they didn't want you to do that when I was a kid. 90 years ago, you couldn't ride your bike on the sidewalk. You didn't know this, but I speed, stick shift, Schwinn Stingray, and they wouldn't let you ride it on the bike on the sidewalk even then.
Okay.
All right. Had you been drinking?
No.
All right, just hanging out.
Yeah.
What do you do, sir? Do you work someplace?
No, I'm not working right now.
What kind of work have you done?
Mostly factory work.
When did you last work?
It's been about good, I don't know, 4 or 5 years, maybe 6.
4 or 5 years. Do you have any money?
No, not right now.
That's probably related to the fact you haven't worked in 5 years.
Yeah.
All right. Well, this ain't exactly the crime of the century. But how old are you?
34 or
Boy, you need to
36.
get back in the
yep.
world. All right. 15 days jail, credit 15 days. You ever been tased before?
No, that was the first.
How did that feel?
Didn't feel good, but it was too bad.
Okay, well, don't make it a habit. Next time, just say yes or no, sir. And They would have just told you to walk your bike home and that would have been it. All right,
Right.
15 days, credit 15 days. I'm gonna waive the fine, I'm gonna waive the attorney fee. The minimum allowable fine is $125 or 2 additional days. Somebody named Michael Warner owns $1,373. I'm not sure those are all you, but I think they are. One of them is a retail fraud from 2025, so I'm not gonna give you a fine that you're not gonna pay. So I made the fine 0. I made the attorney fee 0. If you got $125, you'll get out of jail today. Otherwise, you got 2 more days to do. You're good to
Okay.
go, Mr. Warner.
Thank
Thank
you.
you, Judge. Good luck, Mr. Warner.
Yep.
In this courtroom, the judge carefully listened to every detail before reaching a decision. The court showed patience, fairness, and respect for both sides, while ensuring that accountability remained at the center of justice. The judge's words reflected the importance of responsibility, self-control, and respect for others. Rather than acting on emotion, the court relied on facts, evidence, and the rule of law. This case serves as a reminder that justice is not only about punishment, but also about protecting victims, encouraging accountability, and maintaining public trust. The courtroom once again demonstrated why fairness and law matter in society.
Jessica Lynn Anaya appeared in court facing a probation violation after failing to complete required obligations. During the hearing, the judge reviewed her record and noted that she had already been given multiple opportunities to comply with court orders. As excuses continued, the judge's patience began to wear thin. He reminded her that probation is a privilege, not a right, and that every defendant must take responsibility for their actions. The courtroom grew tense as the judge warned that continued non-compliance could lead to serious consequences. In the end, Jessica received one final chance to correct the situation and prove herself.